Your Honor, there are two issues before this court. One is whether Adam, Jennifer, and Michael are competent and comparable witnesses, and two, whether the CCTV evidence obtained without a warrant should be admissible. Issue 1. Prima facie, the general presumption is that every person is competent and comparable to give evidence on oath in a proceeding as shown in Section 9, subsection 1A and B of the Evidence Act, and in the case of Hoskin against MPC. Under Section 9 of the Section 9 capital A2 of the Evidence Act, one is competent if they can give intelligible account of what they observed and or experienced, and comparable if they can lawfully be required to give evidence as shown in Section 6 of the Evidence Act. Your Honor, under Section 8, subsection 3 of the Evidence Act, Adam, the spouse to Barbara, can give witness even where they are in a de facto relationship as defined in the Act's Interpretations Act. However, Your Honor, as Justice Douglas stated in the case of Callanan against Bush, which overturned the reasoning in Pine case, excuse me, as a co-accused, Adam is likely to be competent but not comparable. Prima facie, Jennifer and Michael are children under Section 21 capital AD subsection A1 of the Evidence Act and likely to be intimidated whilst testifying against their own parents. This makes them special witnesses under Section 2 capital A subsection A and B. Under Section 9b, Your Honor, children are not compellable to give evidence, but can give sworn evidence if they can understand, like in the case of Brazier, and if they cannot lie, or they are not to lie, like in the case of Williams, are not to be coached, like in the case of McKay. If the court finds that they are competent, then they can either give recorded or written evidence made under subdivision 3 and 4 of the Evidence Act, and they should only be cross-examined on relevant issues as described in sections 21 capital AH of the Evidence Act. If video link is to be used, separate place where they will be stationed will become part of the courtroom under sections 21 capital AK subsection 6 and capital AQ. They can have support person, and in this case their grandmother, with them under section 21 capital AL subsection 4 of the Evidence Act. Court should try as much as possible to shield them from their parents. Your Honor, Jennifer has got a severe intellectual disability and she's the affected minor. It is up to the court, Your Honor, to determine her ability to give intelligible evidence. Under Section 9, capital C of the Evidence Act, court can seek expert advice to assess her competency. Your Honor, additionally, because she uses sign language to communicate, under Section 131, capital A, an interpreter could be used to interpret her unedited word-for-word evidence, to be contrasted with the case of Tran. Because her evidence is not of an offense of sexual nature, the court has discretion as to whether Jennifer's case can or can't be heard in open court under Section 2 capital AU subsection 3A of the Evidence Act. Your Honor, Michael is a 5-year-old. It's up to the court to determine his competency to testify under oath. And under Section 9 capital C, court can assign an expert to determine his ability to give intelligible evidence. Because Michael was hiding under the kitchen bench during the assault, it is likely he never saw but heard what was happening. Police must have abided by Section 9A, capital A provisions while interrogating him. Your Honor, the second issue, prima facie, those who enforce the law should abide by it. Police should have a warrant to either search or confiscate any property at a residence under Section 150 of the Police Powers and Responsibilities Act of 2000. However, Your Honor, I submit that the CCTV footage, though got without a warrant, should be included in the evidence because some reasons given in Banning and Cross case can be proven. Your Honor, firstly, it was genuine mistake that Constable Jones took the footage without a warrant. Secondly, this evidence was perishable as it was stored in the co-accused's mobile phone. He was at liberty to delete it at any time before a court warrant would be sought that night. Thirdly, GBH is a serious offense. Jennifer lost sight in one of her eyes due to the actions of the very people who were meant to protect her. This footage is very relevant in bringing the wrongdoers to conviction. It proves who did what and when. Therefore, Your Honor, although described as too high a price by Chief Justice Barwick in the case of bannings against Cross, the footage evidence should be admissible because today's facts widely differ from those in the case of Crown against Day and Ano, where police had plenty of time to get a warrant. Those are the Crown submissions, Your Honor.